call, and then straight down the advantages, tribunals, deference, SOE.
When the affirmative is an advocate test based in plain text. 2. The skills of the link around core positions like core politics and salty arguments challenging the time frame of their case. This is also hurts our counterplan mechanism. 3. This makes it half conditional because they can never articulate any policy change. 4. Kills education because there is no core decision without a test case. 5. In pre-round prep they give us their text and that's all we get for the debate. 6. Voter for fairness and competitive equity. Next off. A Supreme Court will rule in the favor of the states in Massachusetts versus EPA. Washington Post, 2006. The decision of Massachusetts versus EPA could break down political impasse by regulation of the United States and global warming more than economic confident that the rulings in favor of the states is an issue, a matter of if but when. B. The plan trains core political capital to make contentious decisions later. U. 2001. How does the court maintain its legitimacy? The court maintains public support by making legally principled decision to overrule the firearm based on absence compelling reason. The re-examine the watchdog would be so far the court's legitimacy and status quo. Without the legitimacy, the court would be unable to perform its role of interpreter of the Constitution. Many times in the court required to act in popular will in favor of the individual rights. C. A liberal court ruling is key to warming and regulation sends a signal to states and international institutions to act on global warming. New York Times, 2006. The Supreme Court has agreed to rule next fall, and the EPA has the regulatory fishery and Clean Air Act, regulatory greenhouse gas. The outcome will have much to say about the country act aggressively on the problem of potentially grave consequences for the earth and its inhabitants. This is a case of global warming and importance, not least because the Americans act decisively to discourage the rest of the world from acting decisively. D. Global warming causes extinction. Cromwell and Edwards in 05. Humanity has chosen the flow of consumer accelerating imminent contest. We are piling up. Scientists believe the temperature will rise to twice the fast previously thought. Gas barbecue for a small, just 25 years away as the world heats up. Reservoirs of frozen methane could melt, with the consequences that would be terminal fever. Like 10,000 billion methane will be released in the episode of those spinning out of control, leading towards temperatures unseen billions. This is not a prediction. This is a warning. Next off, a uniqueness and internal link. The India deal will pass the lame duck session now, but continued bipartisanship is key. Moen in 2006. The odds are better than even in the favor of the Senate, considering the landing of legislation this week. Strong bipartisan support, encouragement of Republicans, Democrats, nuclear legislation, and lame duck session of Congress. India is fully aware of the intense workload on the final decision and the many time-consuming steps necessary to passage of the bill. In the brief, the new legislation convenes. This includes a vote on Senate floor reconciliation that passed by the House and Senate committee, and a second vote in the House and modifies the legislation. B. Link contentious Supreme Court decision spark partisanship in Congress, stretching the debate in the bills ahead of the India deal. Katzman, 97. As for the process of enacts laws that have become murkier and more complicated, courts have increasing difficulty weighing if various parts of the legislative record. Legislative response to the courts have mangled legislative intent with those imposed by views on society. Congress at times has sidestepped controversial choices by passing the buck to the courts and blames justice for rendering decisions that it forced upon them. C. Impact. If the India deal is not passed in the lame duck session, it will die. Go in 06. This will result in the lame duck for the India-U.S. relation. Nuclear. The bill will have to revert the House of dominated by Democrats, and the process will start from scratch. If this happens, the non-proliferation treaty to try to influence lawmakers to bring amendments addressing their concern. 2. India deal is key to relations. India time 05. India deal is diplomat is explained to U.S. Congressman that the nuclear deal is centerpiece of India's nuclear relation with the United States, and the setback on this front could seriously national interest and take a courageous decision to enhance the impact of strategic relations between these two countries. 3. Relation solves nuclear war. New York Times in 02. Cooperation between India and the United States will be important in talks about added Rust fears between India and Pakistan. These translations, some influence and trust India seeks one more time to the United States in the hopes of seeking sophisticated military technology and help dealing with Pakistan. The United States hoping deeper military and political ties will give Iraq some measures of leverage to prevent war between India and Pakistan that could lead to a nuclear holocaust and would play havoc in the one for Al-Qaeda in Pakistan. Next off. A uniqueness, the new Roberts Court is predicted to be traditionalist and not activist. Wolf in 06. Justice Scalia was the first Supreme Court justice to adopt squarely a traditional approach. Chief Justice Roberts, Justice Alito will likely be conventional traditional approach to judging whether an actual traditional court majority will emerge is impossible to say since it's largely dependent on electoral decisions, but both of which are dependent on many chance circumstances. It is now clear that an intensely practical issue as well. B. Link. Overruling precedent is activist. Marshall in 02. Deference has been a precedent not only conservative hallmark, if there is any, the conservatives have been unabashedly activist. It would be respect to overturning precedent from the moment the court has decided. For example, conservatives have laid claim to the overruling, although the decision has been supposed to overturn the court has rejected central premises that political processes and not the court should be the protectors of the 10th Amendment concerns. Next. The impact of activism to restore rule of law leads to tyranny. Stephen Avoid Note 4. When judges introduce their political views in the courtroom, the danger that the little ability branch of the government check the rulings of the rule and authority of the reserved for Congress judges and the jurisprudence eclipsing the intended limits judicial authority, the collapse of traditional law. D. Tyranny kills millions. It is the most dangerous thing on earth. Roman 97. Contrary to political body, the most anything on earth during this country's war, $38 billion has been spent. At least 170 million were killed by the governments for political reasons. The phenomenon demonstrated that authoritarian, totalitarian governments are more deadly than war. Next off, text. The United States Supreme Court should grant certiorari to the relevant test case, distinguished ex parte hearing decision based on the circumstance of war, not present in the status quo. Competition. The counterclaim solves in the entirety of the case and avoids the decided Supreme Court overruling prior precedent. Solvency. Distinguished carries strong away the warning. Hold no 5. Distinguishing the facts of prior cases for a powerful form of tax on the president since the application of power analogy in logical terms. The analogy defines sufficient condition in the decided case at hand, whereas the distinguished case defines necessary condition for applying the rules cited as lacking. 2. Distinguishing Kieran solves case FC no 5. Judges bestow on presidential authority deciding times of war, attorneys seek the responsibility to distinguish these lines of circumstance, something like an elephant in the room that tries to might ignore the elephant's presence. In other words, our prescription provides a framework for balancing security and liberty issues and different sides without relying on judges in this bill to refrain from an understandable urge to exercise emergency powers compatible with constitutional norms. Next on case tribunals. 1. Turn to military tribunals only way for trying detainees while risk of triggering terrorism. Volcano 4. Military commission can provide the protection of the accused judges, prosecutors, and counsel, courtroom judges, and participants, given that the courtroom itself cannot be a terrorist target. A U.S. military commission convene a U.S. military installation of security measures, and one that's isolated from civilian attack population as a U.S. military commission can adequately protect classified and ongoing operations while involving the United States security, safeguarding, preserving such highly intensive imperatives and U.S. National Security Commission probative to a responsible person's standard evidence applies to both the prosecution to the defense of the military, retrieval, maintenance, and priority chain of custody, continue safeguarding, ordering ongoing military operations, general chaos, and associated international armed conflict and battlefield amplified problem. 2. Terrorism causes extinction. Alexander No. 3. The international community failed to understand the magnitude and implications of terrorism civilization network. The terrorists have introduced a new scale of violence, conventional, not unconventional threats to impact biological, chemical, radiological, nuclear, cyber with the impairing national, regional, and global security concerns. Next, onto the deference. 190, the Hampton decision set up a precedent for judicial strength in the war on terror. Even if the courts didn't rule constitutional, they did rule. The president doesn't have plenary powers. 2. Turn. Deference is essential to military readiness. Again, 94. Specialized society warrants a separate system of adjustments. The military can point to the separate community to doctrine of the Supreme Court's application, a degree of deference to Congress in any case in addressing military issues where the needs conflict with the service members' individual rights. Civilian courts do not need to complement. 2. Determine and protect these rights without decreasing military efficiency. 3. Readiness prevents global war. Calazan 95. The main deterrent of the global rival in military power in the United States is an adequate level of military capable of facilitating such event. U.S. tradition secret defense cuts a serious probability. Historically, the United States has made an arrow indication by downselling for the United States maintaining preeminence to acquire increased capability to prevent and defend. The defense of the force at adequate size can discourage a rival power by making potential rivals believe the catching of the United States is a hopeless proposition. If they try, will suffer the same fate as the former Soviet Union. Next, onto the SOE. When he sees call for extension of law to the state of extent and ignores the violent exceptional nature of politics, the liberalism only through the law can the state of extension and control. Cohen 06. Government's type of the liberal view, more vigorous enforcement of the law means combating cruelties and excesses carried out by the emergency powers. History of the state exception establishes the phenomenon of political reality that has proven remarkably resistance to legal limitations. Foreground the link between the state of exception and more fundamental intrinsic politics, the sovereign declare war against state of exception and exclude a bare life of the invest in the individual worth of rights. The two are intrinsically linked. The legalism, anemic strategy for combating the power of fascism, the power that the conservative forces ruthlessly invoke to further their agenda. The moderate Weimar center left paralyzed, fighting with the military left with decisively against the authoritarian right partisans of the passively acquiesce to their own feet. Furthermore, the rule of law proved to be unliable to a struggle against violence. Any further obscure the zone of indistinction between exception to operate foreground the law serves to legitimize sovereign power, since sovereign power is fundamentally the power to place people in the category of bare life. The law both produces and legitimizes marginality and exclusivity. Next, furthermore, the extension of human rights regime to detainees mass the ability to state to create a state of exception at any time by extending the rights of detainees. They make it perfectly legal for Bush to render detainees, creating a real zone of exclusion. No one else likes. Renditions, assurance, no regression in state of nature, reaching back to the secrecy of the human rights laws, perhaps have been open, rigorously and transparent. The sovereign negotiating table, breaking up specifically treating on human rights. Single rendered person, where states begin with their human rights bilaterally, individually, largely undisturbed. Critique of the advocates. It must be apparent that there is no emancipation of rights in the state authority. The recall element.
Okay, let's talk.
What's the status of the conference?
Okay.
disposition mode.
What does that mean?
That means we have to go for a 2 straight turn.
All right. Explain your test case argument.
Well, it's not in your plain text, and what that allows you to do is make no link arguments on court politics, saying that, well, we're just making an act. Like, the court could just say to newspapers or reporters, like, oh, yeah, this is a bad idea that we're doing this. And I think those arguments are bad. Also, it's pretty wrong prep. For that same reason.
How's it abusive?
Well, for the link debate, and also it hurts our ability, like, on counterpoint mechanisms. It allows you easier to get out of those debates, like make no link firm arguments.
Can you explain the kind of
The counterplan distinguishes Kieran rather than overruling it. So it says, like, look, if Congress declares a war, which they haven't done, and they haven't done in a while. Well, they did it in Iraq, but that's already done and over with. But when they declare a war, then the president can detain all he wants and make, like, any distinction he wants. So basically, Congress would be the ultimate. Congress and the Supreme Court would be the ultimate check. Like the Supreme Court, like we get access to your deference. This is how we get access to deference. Is, you know, the Supreme Court creates this limit by the counterplan, and then Congress would have to vote on a war before any type of abuse. So we would solve all of your Gitmo claims and all of your state of exception stuff because it would be illegal for Bush to do that right now. Because the war on terrorism is purely rhetorical. There is no declared war by Congress.
Okay, what's the net benefit? Just all the disadvantages?
Yeah, distinguishing has less of a controversial impact. At the point where it's not infringing upon press powers that are articulated in the Constitution, which have never been addressed by the Supreme Court in ways to limit the power of the government in, beyond the 200 years of constitutional law interpretation, they've never limited. So that would be that would force like a total rethinking. But saying that Congress didn't declare a war is something that has been discussed, not as controversial.
What were your arguments on the state of exception? I have this ignores violent, essential political liberalism, and what else was there?
Pardon?
Well, what's after the political liberalism?
After the political, it's that like the government will just use renditions. It's a really good card that says, look, specifically they'll just create a state of exception by having the CIA send people to, Kazakhstan to be tortured.
So those are the two arguments you had, or were there more?
No, these were the only two on.
Okay. Can you explain the arguments on the Cohen card?
The first card?
Yeah.
Oh, it was that
That's fine. Can I just see it?
Yeah, sure. No, it's that by making those calls,